The Bogosity Podcast, early and ad-free. Become a subscriber at Patreon, Subscribestar, or Discord. Use the links at donate.bogosity.tv.
Welcome to the Bogosity Podcast for the week of January 12, 2025. The podcast that's going up the tubes. This is your host, Shane Killian. Let's gothicize the news of the bogus. And as usual, we begin our first regular podcast of the new year with a look at what has now come into the public domain, which in the United States means books, films, and other works released in 1929 and sound recordings published in 1924. The characters Popeye and Tintin are now PD, although not necessarily any depiction of them in media, as well as the earliest Tarzan comic strips. For music, we have Gershwin's An American in Paris and the first recordings of Rhapsody in Blue. We also have Ain't Misbehavin', and if you're confused because that's a Fat Waller song and should already have been PD, well, it has an additional composer in Harry Brooks, as well as lyricist Andy Razzoff. Other songs include Can't We Be Friends, Stardust, What Is This Thing Called Love, Am I Blue, and Singin' in the Rain, although again not necessarily any sound recordings such as the famous Gene Kelly rendition. There's also the full score to Maurice Ravel's Bolero. Film-wise, we have the Marx Brothers making the leap from vaudeville to the big screen in The Coconuts, the musical Showboat, Alfred Hitchcock's first sound film Blackmail, Cecil B. DeMille's first sound film Dynamite, and in Mickey Mouse cartoons, sound versions of The Galloping Gaucho and Plane Crazy, as well as The Carnival Kid, the first one where Mickey speaks, and The Opry House, the first time he wears gloves. We also have the famous Silly Symphony cartoon, The Skeleton Dance, as well as 4 others from the series. In addition, there's Hallelujah, one of the first major studio films with an all-African-American cast. For novels, we have Hemingway's A Farewell to Arms, the first English translation of All Quiet on the Western Front, Faulkner's The Sound and the Fury, Burroughs' Tarzan and the Lost Empire, Agatha Christie's The Seven Dials Mystery, and Patrick Milton's play Rope, which was later made into an excellent Hitchcock film that everyone should absolutely watch. There's also Bertrand Russell's book Marriage and Morals, and Ludwig Wittgenstein's essay Some Remarks on Logical Form. Additionally, William Seabrook's novel The Magic Island is notable for introducing the world to zombies. In the world of art, we have Salvador Dali's The Great Masturbator and the Accommodations of Desire, M.C. Escher's print Strada di Scano, and all the works of Henri Matisse. I'd love to tell you that Magritte's The Treachery of Images is PD, but it's complicated and no one really knows because copyright law sucks. I mean, generally as well. They weren't PD last year, so ask yourself if Hemingway, the Marx Brothers, and the rest would otherwise have just said, what's the point of doing this if it's gonna be free for everyone in 2024? Just thinking about what isn't public domain, but by all rights should be, tells you once again that serious reform is needed, as well as questioning if there's any ethical validity to the whole concept to begin with.
Sometimes you just have to stomp some skulls. From the mind of Mr. Dapperton, a game for the ages. In a world where a race of undead furries tries to take over the world's nuclear arsenal, one man must stop them. But which man? You choose. Dapperton. Elon.
Not my Dogecoins.
Joe.
Build me back.
Shapiro.
My kippa's ruined.
Or Don John.
Ow, my ear.
Forget those losers. You know you want to play as me, Lord Killian. That's right. You can stomp the skulls of those commie furries and save the universe as me.
7 complete different worlds with more coming all the time. Full controller support. You can even get eaten by a worm and pooped out into a furry cathedral. You know you want this game. Go to links.bogosity.tv/skullstompers and play Skull Stompers now.
You know, as long as I've been doing this podcast and doing political commentary for even longer, I still see things that completely amaze me about just how terrible politicians can get. In this case, it's about a petulant, vindictive child in the form of outgoing St. Louis City Sheriff Vernon Betts, who really didn't like incoming Sheriff Alfred Montgomery, so he decided to take documents and even furniture from the office. He also withheld access codes and even refused to give him his credentials when he took office. Also, Betts and his deputies are accused of intimidating deputies, denying Montgomery access to the property room, and taking documents and file cabinets from the building. It could affect court cases and in some cases even result in mistrials. Montgomery and his team were even blocked from entering the building. Betts refused to even speak to Montgomery. Montgomery said, quote, "As I look at it, Democrat Biden and Republican Trump are transitioning their office. If they can do it, why can't two Democrats in the local city do it as peacefully as the presidency?" Betts simply said, quote, "There's nothing to talk about." So Montgomery, who defeated Betts in the Democratic primary after Betts filed for a recount which showed that Montgomery won by at least 221 votes, filed a temporary restraining order against Betts and his deputies. The trouble between the two began when Montgomery, who had been working as a deputy, announced he was running against Betts, whereupon Betts instantly fired him. This is what happens when politicians feel that they're basically God and can act with spite, engage in graft, and be above all accountability for their actions. It happens at the national level, and this shows it can happen at the local level too. In fact, I'd be surprised if this sort of thing didn't happen all the time. Perhaps it's time to start pointing it out more when it happens. If you're on the Wi-Fi in a coffee shop or hotel, anyone on that network can get your traffic. Do you really trust all of those strangers? For that matter, do you really trust your ISP? A VPN can protect you from prying eyes, disguise your location, and even foil government censors. It's essential in this day and age, so go to vpn.bogosity.tv and you'll be taken to BoxPN. Starting at just $2.99 a month, you can get unlimited high-speed connections to VPN servers all over the world, and they don't log connections, so your privacy is assured. Traveling abroad, just VPN home, and don't worry about what those other governments are doing. Back at home, stop your ISP from traffic shaping and messing with the quality internet access you're paying good money for. You can connect from multiple machines at once, including your smartphone or tablet, and it supports all the secure standards, including OpenVPN and SSTP. Bypass censors and surveillance with your own secure VPN connection. Go to vpn.bogosity.tv. Oh, the friggin' Supreme Court, I'm telling you. Earlier this year, as we covered, they had to clarify what they'd been saying multiple times going way back to Marbury v. Madison, that the president has immunity for his official acts. No one else in government can second-guess his decisions because that would make that person superior to the president in the executive branch, and that just isn't what the Constitution says. In fact, that concept, separation of powers, is one of the most important tools the Constitution has for stopping the government from getting too far out of control. So much of what we've covered over the years about government getting out of hand is related to the different branches corruptly colluding with each other. And it was so obvious and well understood that the Supreme Court upheld it 9-0, unanimous even among the liberal justices. And now it's come time to actually enforce it. And they've completely dropped the ball. So we've been following the astoundingly corrupt Trump hush money trial under Judge Juan Merchan, the man who donated money to Biden and whose daughter not only raised upwards of $100 million campaigning for Biden, Adam Schiff, and other Democrats, did so using that very same trial. The one where the star witness was a serial perjurer. We don't need to rehash all that again, do we? Almost everything in the trial had to do with Trump's official acts as president. It had to do with payments made to White House counsel Michael Cohen, the aforementioned perjurer, using testimony from Cohen and other White House employees. Absolutely 100% immune. Judge Merchan corruptly and without any justification repeatedly denied immunity and denied a stay of proceedings while immunity went up to SCOTUS. So Trump filed another interlocutory appeal based again on immunity to overturn the conviction and stop the sentencing. According to the Coinbase precedent, that should mean staying all proceedings until the appeal is decided. Merchan refused to do so. So Trump made another interlocutory appeal regarding the stay all the way up to SCOTUS. And the same 9 justices that unanimously voted for immunity denied it 5-4. Thomas, Alito, Gorsuch, and Kavanaugh all would have granted the application. That means that not only the 3 liberal justices voted to deny it, but also Roberts and Barrett. As we've covered before, the basic makeup of the court is 3-3-3. 3 conservatives, 3 liberals, and 3 institutionalists. But now, it seems that on the emergency docket at least, we're back to having a 5-4 court. The coin flip we've covered over so many years on this podcast. We saw the exact same split last year in the Border Patrol razor wire case. It seems that Kavanaugh actually understands the importance of emergency relief, whereas Barrett is only willing to grant it when it comes from the Fifth Circuit. What we then see is that usually Roberts and Barrett will vote with the conservatives on the merits, but with the liberals on the emergency docket. We do have a brief explanation as to why the stay was denied, and it shows the problem we're having here in crystal clarity. It begins, quote, "Application for stay presented to Justice Sotomayor and by her referred to the court is denied for, inter alia, the following reasons." The first point is exactly what we've come to expect from Barrett, quote, "First, the alleged evidentiary violations at President-elect Trump's state court trial can be addressed in the ordinary course on appeal." Yep, kicking the can down the road and letting the defendant suffer. But immunity is supposed to protect you from the process as well as the punishment, and you need look no further than the Supreme Court's own precedents to see why. But in Trump v. United States, Barrett disagreed with the majority, saying that she would have allowed immune actions to be admitted as evidence in the trial. She went against centuries of precedent to say that the doctrine of immunity doesn't allow for interlocutory review and was only to be raised as a defense. And that would have resulted in open season for every single president to be stuck in court for life, as one state prosecutor after another in the opposing party all over the country keeps second-guessing their official acts. The other point is Roberts all the way, quote, "Second, the burden is that sentencing will impose on the president-elect's responsibilities is relatively insubstantial in light of the trial court's stated intent to impose a sentence of unconditional discharge after a brief virtual hearing." In other words, since Merchan pinky swore not to actually punish Trump with finer imprisonment, since the whole corrupt purpose of the kangaroo court to begin with was to be able to hang the sign felon on Trump, the only negative effect on Trump will be having to sit through a hearing. But, of course, Roberts doesn't say anything about what these responsibilities are and what would go beyond relatively insubstantial. The whole point of immunity is to cut it off at the source so that you never even get to that question to begin with. And what even is the benefit of allowing things to go forward given that there isn't going to be any punishment? Roberts doesn't even do that balance of burdens thing. Of course, immunity says you don't do that, but in the other direction, you grant immunity to cut off the process at its knees. Roberts defaulted the other way. He has no rational basis whatsoever for his denial of the application. What he also didn't even try to answer, what if Merchan changed his mind and decided to imprison Trump? And remember, if this were congressional immunity or judicial immunity or any other kind of immunity, it would have been that way, cut off in an instant, or if not, granted an interlocutory appeal. Hell, it's even that way with the corrupt and completely made up qualified immunity for cops behaving badly. And it's also supposed to be the case for the immunities that you have. The right to free speech, to freedom of religion, to peaceably assemble, to keep and bear arms, to be secure in your person, houses, papers, and effects, and so on. Anything that violates these gets stopped instantly. Once again, consider, if they can deny that to the president, what's to stop them denying it to you as well? Or if they turned it from a fundamental human right into a mere defense, and they made you go through the entire process with all of the expense and reputational harm that ensues, saying you can only appeal afterward. For Trump, this isn't actually so bad, and it probably is better for his entire appeal to be heard on the merits. It's what it means for you and me that's the issue here, as it has been with all of this lawfare. We've already seen cases where these precedents are being used against regular people. How many will we see in 2025? And now it's time to iberitate this week's biggest bogon emitter. So yeah, let's talk about Judge Merchan's sentencing since he's this week's recipient. I mean, the sentencing after all was a quick hail and farewell, or more literally, Godspeed. Trump was sentenced to an unconditional discharge after being found guilty on charges of whatever the jury felt like. Here's what Merchan allowed prosecutor Joshua Steinglass to claim.
In finding the defendant guilty in this case, the jury necessarily found, unanimously, that the defendant falsified 34 separate entries in his business records with the intent to defraud, which included an intent to commit or conceal a conspiracy to promote his own election by unlawful means.
Actually, they didn't. Remember that no such crime was charged or even alleged. Remember our previous coverage. Merchan just said that was one of the offenses the jury could pick if they wanted to, but they could also pick any other, and they didn't even have to agree among themselves.
Having presided over the trial, Your Honor is very familiar with the conduct, its seriousness, and the overwhelming evidence to support the jury's verdict. I'm certainly not going to rehash that now.
Yeah, 'cause doing that actually on audio where no one can deny it, unlike the rest of the trial where that was prohibited, would give us direct evidence we could play of how corrupt you are.
In last week's decision on January 3rd, this court referred to the gravamen of the defendant's conduct, his criminal conduct in this case, as constituting, quote, premeditated and continuous deception. The verdict was delivered by a jury that was carefully chosen using an extensive questionnaire based on suggestions from both parties and after thorough questioning of the prospective jurors by both sides.
Oh my God, this guy! We covered how absolutely one-sided this was. Basically, no suggestions from the defense were allowed in, just like defense witnesses, including expert witnesses, weren't allowed, including an expert on the aforementioned intent to commit or conceal a conspiracy to promote his own election by unlawful means, on the very basis that it was irrelevant because Trump wasn't charged with that.
Far from expressing any kind of remorse for his criminal conduct, the defendant has purposefully bred disdain for our judicial institutions and the rule of law. And he's done this to serve his own ends and to encourage others to reject the jury verdict that he finds so distasteful. He has characterized these proceedings as corrupt, rigged, a witch hunt, or a sham too many times to tabulate.
Yeah, imagine that. He used his freedom of speech to call a corrupt court corrupt. At least as far as he could without violating the blatantly unconstitutional gag order that persisted even after the jury verdict. Alright, we're gonna skip the rest of what this flunky says, other than to summarize the continued deception that Trump is saying dangerous things that threaten democracy, blah, 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 basically denying the entire Brandenburg decision. Alright, let's hear some of what defense attorney Todd Blanche had to say, which, funnily enough, wasn't quoted anywhere near as often by the news media.
What the government just said presupposes something that we disagree with very much, which was that this was an appropriate case to be brought. It was not. This case, without a doubt, knowing everything we know about the timing of the investigation, the fact that multiple prosecutors looked at the facts of this case, including prosecutors within the district attorney's office in New York County, and made a decision not to bring charges.
And of course, they only brought back this zombie case when their other cases against Trump failed one by one, timed specifically to interfere with the election for all the good it did them. And remember, we covered the opinion of numerous legal experts confirming that, including many on the left, this just isn't a valid case in any way. And as Trump himself pointed out in his remarks to the court,
this is a case that Alvin Bragg did not want to bring. He thought it was inappropriately handled before he got there. A gentleman from a law firm came in and acted as a district attorney, and that gentleman, from what I heard, was a criminal or almost criminal in what he did. It was very inappropriate. It was somebody involved with my political opponent.
And he reminds the court that the so-called falsification was made by Trump's accountants marking down legal fees paid to his lawyer as legal fees. In fact, there just wasn't any other option in the software's drop-down box that would have been at all relevant to it.
Jonathan Turley, Andy McCarthy, Judge David Rifkin, a wonderful man who just passed away, by the way, Greg Jarrett, Ellie Honig from CNN, of all places. CNN said that, Paul Ingratian, Alan Dershowitz, they all said this is not a case that should be brought. But the fact is that I'm totally innocent. I did nothing wrong. They talked about business records, and the business records were extremely accurately counted. I had nothing to do with them. That was done by an accountant or a bookkeeper who I think gave very credible testimony and was corroborated by everybody that was asked.
All right, let's go to Mershon himself, because from everything you've just heard, and especially if you've been following my coverage of all of this, you'll know how ridiculous it is and how blatant it is that this is the only part of this entire trial he's allowed to be broadcast or recorded in any fashion.
Never before has this court been presented with such a unique and remarkable set of circumstances.
Well, that's one thing he said that's correct.
The legal protections, especially within the context of a criminal prosecution, afforded to the office of the president have been laid out by our founders, the Constitution, and most recently interpreted by the United States Supreme Court in the matter of Trump versus the United States, which was decided on July 1st, 2024.
And which, as we covered, you repeatedly ignored and denied, as he then goes on to say,
to be clear, the protections afforded the office of the president are not a mitigating factor.
I mean, are you actually serious? What if it were a gun charge and he said your Second Amendment rights weren't a mitigating factor? Or you were arrested for protesting and he said your First Amendment rights weren't a mitigating factor? And he repeatedly called Donald Trump an ordinary citizen and said,
no, ordinary citizens do not receive those legal protections.
Even though he was the president in 2017 when all of the alleged activity took place. This is absolutely unbelievable. And where is anyone else pointing this out? Listen to the hearing and hear it for yourself. After all this, only Judge Juan Mershon could be this week's biggest bogon emitter. I want to tell you about the eyeglasses I've been wearing for years. As people can see on my videos, I have a very strong prescription, which makes glasses more expensive, especially when I need computer glasses, reading glasses, prescription sunglasses, and most expensively, progressive lenses for general everyday wear. To save money while still getting quality glasses, I get them from Firmoo. In fact, I just got a pair of progressives with high-index aspherical lenses and a nice pair of frames my wife loves for just over $100. It would have been $500 to get them through my eye doctor. Not only do they look good, the glasses are durable. I've worn many pairs for several years without problems. All orders come with a 30-day return policy, a 3-month warranty, and one-on-one customer service. Go to Firmoo, that's FIRMOO.Bogosity.tv anytime you need quality glasses at a low price. Once again, that's Firmoo.Bogosity.tv. All right, let's start off the year with our very first recipient of the Silver Kluwan Award. And it's the second for co-founder, chairman, and CEO of Meta Platforms, Mark Zuckerberg. He got his first for plainly laying out the case for AI being open source. Now he gets his second one, and again, this is more for who is saying it than what's being said. While his stance isn't significantly different from Elon Musk's, it's such an about-face for him that it reverberates throughout cyberspace.
I want to talk about something important today, because it's time to get back to our roots around free expression on Facebook and Instagram. I started building social media to give people a voice. I gave a speech at Georgetown 5 years ago about the importance of protecting free expression, and I still believe this today. But a lot has happened over the last several years. Governments and legacy media have pushed to censor more and more. The recent elections also feel like a cultural tipping point towards once again prioritizing speech. So we're going to get back to our roots and focus on reducing mistakes, simplifying our policies, and restoring free expression on our platforms. We're going to get rid of fact checkers and replace them with community notes, similar to X, starting in the US. The fact checkers have just been too politically biased and have destroyed more trust than they've created, especially in the US. So over the next couple of months, we're going to phase in a more comprehensive community notes system.
Yes, he's going to convert Meta's platforms, including Facebook, Instagram, and Threads, to the system that X innovated, free speech moderated by community notes. He basically confirmed Masnick's impossibility theorem, that it's difficult to moderate well and impossible to do so at scale. All you can do is the best you can do, and do it in a way that takes the power away from government. Also, like Musk did with Tesla, Zuckerberg is going to move Meta from California to Texas, where hopefully there won't be the same level of political pressure to censor. But as he pointed out, the problem goes way beyond the U.S.
The US has the strongest constitutional protections for free expression in the world. Europe has an ever-increasing number of laws institutionalizing censorship and making it difficult to build anything innovative there. Latin American countries have secret courts that can order companies to quietly take things down. China has censored our apps from even working in the country. The only way that we can push back on this global trend is with the support of the US government. And that's why it's been so difficult over the past 4 years when even the US government has pushed for censorship. By going after us and other American companies, it has emboldened other governments to go even further. But now we have the opportunity to restore free expression, and I am excited to take it.
You might disagree with me here. It seems that a lot of people are saying that Zuck is only doing this because the political winds are changing. But maybe this is a side effect of what I said last week, that with just 2 winners last year, I should try and be less cynical, but I really don't think that's the case here. I mean, you don't see YouTube shifting with the political winds, do you? And they're 1,000 times as political as Facebook ever was. And there are still plenty of people in the administrative state who are willing to bully him over this, as we saw with the Facebook files, where Facebook resisted and did all of this very reluctantly. And those people will still be there for some period of time after Trump takes office, even if he does make good on his campaign promises. So there is still a good amount of risk here, and Zuck is going against what all of the other political actors in this space are doing to align himself more with Elon Musk and X. It seems that, at the very least, he's got enough people in his corner to help him stand up to the government bullies. And just showing that to be the case is enough in my book. YouTube and the rest are now without excuse. So enjoy your second Silver Kluwan, Zuck. Just please make sure to keep it clean and shiny for years to come. Do you have children, or nieces or nephews? Are you homeschooling, or just want to counter some of the socialist indoctrination most children get in school? If so, go to bogosity.tv/TuttleTwins, and you'll be taken to a website where you can get some great books for elementary-aged children. The Tuttle Twins books are books about liberty and free market economics that include children's versions of Bastiat's The Law, Leonard Read's I, Pencil, and Hayek's The Road to Serfdom, as well as books about the Federal Reserve and how regulations protect business cronies. They'll learn about the harm caused by eminent domain, or regulations passed in the name of safety, and fundamental concepts of liberty. And as you can see from the sample pages on the website, they're all easy to read and nicely illustrated. They're just $9.99 a piece, or get a special discount as well as free bonuses when you purchase all 5. You can even buy in bulk to donate to schools and local libraries. So get the Tuttle Twins books at bogosity.tv/TuttleTwins. And now let's disconcertionalizationalize this week's Idiot Extraordinaire. And Fannie Willis racks up another one. Will this stupid woman never learn? I mean, how many chances was she given? How many months' notice did she have? She knew full goddamn well that she had to comply with the Georgia Open Records Act, as we covered before, and she still kept refusing to do it. Did she think she was just above the law? Did she think it would just go away if she stuck her fingers in her ears long enough? Well, now she's been ordered to pay $21,578 in attorney's fees for her office's noncompliance. This stems from the Open Records Act request from Judicial Watch to obtain records of her communications with the Jan 6 committee and Kamala Harris's office. Maybe she just feels it's worth $21,000 not to turn it over, in which case those records are much more damning than we ever thought. Judge Robert McBurney ruled, plaintiff submitted an ORA request to defendant on 22 August 2023. That same day, plaintiff received confirmation that its request had been delivered. The following day, the county's open records custodian sent plaintiff an email confirming that the district attorney's office had received the inquiry and asking plaintiff to simplify its ORA request. Literally 5 minutes later, before any simplification had occurred, plaintiff received a second email from the records custodian. After carefully reviewing your request, we do not have the responsive records. This response was perplexing and eventually suspicious to plaintiff, given that plaintiff subsequently covered through own effort at least one document that should have been in the district attorney's office possession that was patently responsive to the request. Then she went all kettle logic on them. They had no documents, and the documents were exempt. Quote, somehow something had changed. Despite having previously informed plaintiff 4 separate times that her team had carefully searched but found no responsive records, now there suddenly were, but they were not subject to disclosure under the ORA. Plaintiff's deposition of defendant's records custodian shed some light on this mystery. He admitted that there was no search for records back in August 2023, just a no go away. But as the judge pointed out, compliance with the ORA is mandatory. Quote, non-compliance has consequences. One of them can be liability for the requesting party's attorney's fees and costs of litigation. To recover its relevant and reasonable fees and costs under the ORA, plaintiff must do 2 things. First, it must show the defendant violated the ORA. Second, plaintiff must also demonstrate that defendant lacked substantial justification for the violations. Most basically, by operation of law, defendant acknowledged violating the ORA when she defaulted. But actual evidence proves the same. Per her records custodian's own admission, the district attorney's office flatly ignored plaintiff's original ORA request, conducting no search and simply and falsely informing the county's open records custodian that no responsive records existed. We now know that that is simply incorrect. Judicial Watch has also moved for the court to appoint a special master to oversee Willis's search for records to submit to the court for in-camera inspection. Willis has until the 16th to respond, if she even does. Judicial Watch President Tom Fitton said, quote, Fannie Willis flouted the law, and the court is right to slam her and require, at a minimum, the payment of nearly $22,000 to Judicial Watch. But in the end, Judicial Watch wants the full truth on what she was hiding. Her office's political collusion with the Pelosi January 6 committee to get Trump. There is evidence of collusion to illegally manipulate an election, but not by Donald Trump. Democrats through and through, as we've seen over and over again, did everything they could to try and throw whatever they could at Trump. And in just 8 days, he'll be president again. Gee, it's almost as if those tactics always backfire. I just don't get it. I just don't get how anyone could be as mind-blowingly stupid as Fani Willis. Corrupt is one thing, but corrupt and stupid, whole other level. So all of that makes Fani Willis this week's Idiot Extraordinaire. Well, that wraps up this Villains Full of Villainy edition of the Bogosity Podcast. I hope you enjoyed it. If you did, please go to donate.bogosity.tv for several ways to support and discord.bogosity.tv to join the discussion. Subscribe to the Discord or at Patreon or Subscribestar, and you can listen early and ad-free. Thank you for listening. Until next time, here's a quote from Albert Camus. The welfare of the people in particular has always been the alibi of tyrants, and it provides the further advantage of giving the servants of tyranny a good conscience. The Bogosity Podcast is licensed under Creative Commons Attribution Non-Commercial No Derivatives 4.0 International License.
Bogosity.